Hi, so let's deal with question one. Question one deals with the question of the case of the Union Government versus Warneke or Warneke 1911 as it relates to the topic of harm. There's a hint. It says you need to provide the background information on the topic of harm in general for the reader to understand your discussion of the case. So in order to answer this question, when they says as it relates to harm, and you need to provide a background information on this topic, so you get what is it? It's like a sign, obviously, that says you need to tell your reader what harm is. Okay, so you need to explain to your reader what harm is. So the definition of harm, you can find it on your textbook, obviously, depending on what textbook you're using. But my definition of harm is a mix of textbook and obviously the knowledge. But if they say you need to cite the textbook, then you look up the definition on the textbook and then you start with your definition. So harm is the legal concept of damage or injury suffered by a person or their property as a result of another person's wrongful act or negligence, right? It is a concept of damage or injury suffered by a person or their property as a result of another person's wrongful act or negligence. So from that definition on its own, we can already see a couple of elements like wrongful and negligence. And that should also tell you something if you have been studying. Okay. So in Delict, in order to establish a delictual claim in South Africa, obviously, in our legal system, one needs to prove the delictual elements, right? So you will already know by now that harm is one of the delictual elements that need to be proven. So in order to establish a delictual claim in South Africa, one needs to prove the delictual elements, and those include harm. You would obviously know what these delictual elements are, and I am not going to go into detail with these delictual elements. I will assume that you already know these 5 elements, okay? And so those elements are harm, conduct, causation, fault, and wrongfulness, okay? They are harm, conduct, causation, fault, and wrongfulness. Okay, so for a delict to arise, there must be some actual or potential harm. So we said we are giving a background information on the topic of harm so that our reader can be able to understand what harm is. And with that, we'll also discuss the Union Government versus Warneke 1911. Okay, so depending on the type of harm, let me just take you away a little bit, right? So depending on the type of harm, there are specific remedies that apply. So we will talk in detail about the remedies in the future study units. And then if you kind of like pressed with regards to the remedies, you can leave you can send me a message or comment, and we can discuss that. But for now, let's talk about the specific remedies that apply for the purposes of harm. right? So we all know what patrimonial loss is. I'm also not going to dive into that right now. So harm is patrimonial, and the compensation will follow only if the lex acquire elements are present, right? And then there's also pain and suffering. And then for pain and suffering, the elements of the Germanic remedy must be present, right? And then in terms of defamation or violation of a personality interest, the elements of actio injuriarum must be satisfied. In this way, you determine the route to follow and which requirements to be met for your action to be successful, right? So if you understand the remedies and what kind of conversation must follow, then you will definitely not go wrong. Okay. So let's talk about this case. So in a nutshell, this case for the Union Government Vs Warneke 1911. So in this case, a woman died in a train accident and her husband sued the minister for loss of comfort and companionship and the loss of his wife's assistance in caring and for bringing up their children. So in this case, the court found that the lex aequalia served to compensate only in respect of calculable pecuniary harm. So let's stop there for a minute. So the court found out that the lex aequalia, like the first remedy that I spoke about, it only saved to compensate in respect of calculable pecuniary harm. So what is this pecuniary harm? Okay, it is the economic losses that can be easily quantifiable, like money lost, future earnings, medical bills, and so on, right? So the court could not attach such an economic value to the loss of his wife's comfort and the society. And so the husband's claim failed in that regard. That was a judgment by de Villiers, the Chief Justice. Okay. So, however, the extent to which the husband could show that the deceased spouse had provided assistance in caring for and supporting and educating their children, he could claim for any expenditure incurred to provide care and assistance to similar to that which his wife had given him during the lifetime. That was another judge, that was Ines J, not judge, justice, sorry, Ines J. So he said if the husband can show proof that his wife provided that kind of assistance that he was claiming for example, for caring for their children, supporting the children and educating them, then he would have a claim for any expenses that he would have incurred to provide such to their children. Okay. So in this particular case, we can already see that it involved two types of claims, and one of them is patrimonial loss, and then the other is non-patrimonial loss. If you don't know what these are, please let me know, then I'll be able to dive into it, but I don't want to waste a lot of time explaining things that you already supposed to know. So the court did recognize the patrimonial claim, but it didn't consider the non-patrimonial harm to be actionable under this lex aequalia action. And then it said the Aqualian action was confined to cases in which a calculable pecuniary loss has been actually sustained. You still remember what that pecuniary harm is: economic losses that can be easily quantifiable, in monetary value. And also the court considered that where the actio uniarium applied, but it found out that since there was no injury done to or dishonor brought up upon the husband, there was no cause to satisfy any injured feelings. So in this judgment, the normative component of the harm elements comes clearly to the fore, and the court has to decide whether the two types of harm were actionable in the absence of any previous authority. So in considering whether the husband had sustained patrimonial harm, both the savings and additional expenses arising from the wife's death should be considered. And this is what the court said, if the savings exceed the expenses, then he could have suffered no harm, right? Which is what happened in the Santam case versus Warneke. So the question also says critically discuss. Okay, so now we have discussed the case, and now we have to look at it critically. Okay, and then you can obviously show those in your summary or in your critical discussion. Okay, so if I had to critique this judgment, I would start with the fact that this is a very old case. It was decided in 1911, and it was relevant at that particular time. But we live in a fast-paced, evolving world where things change on a daily basis. And on this particular note, I would look at the gender bias, where the judgment is very reflective of the societal norms and the legal principles of its time, which were often gender biased. And it clearly assumes that the wife's primary role is to provide care, clothing, and upbringing of the children. And they're very much, the court is very much in support of that. That's one of the points that kind of stand out, because the husband will obviously be compensated for that. I mean, as he should be compensated for that, because he lost a wife, somebody who was, taking care of those things and supporting them day to day. But the fact that the court also recognizes that the wife's role was to care and provide, I would say, the way I would critique it, it's very gender biased. In this world that we live in right now, I don't think that the gender roles should be permanently fixated for women taking care of children and so on and so on. Okay, and then my second point will be the lack of emotional damages, because I know obviously even now the courts do not really cater for emotional damages, but in this particular case, the court was so concerned with the pecuniary losses, and they excluded the emotional damages, which I think they can make like a valid and a solid argument. Yes, I know they would say that, I mean, people die, people lose their husbands or their wives every day, and so the court does not pay for grief and so on, which is quite understandable, because we would have over-flooded courts where people are going to claim for grief and so on. But I feel like the court should have at least looked at the emotional damages and see what these men can be compensated for. So it's really on a scale of you need to like kind of think out of the box and look at the decisions that the court were made, if they align with the changing times that we are in, and so on and so on. Like I think it was my first point. You can kind of categorize or box that one under the historical context, you know, and kind of emphasize that, you know, the judgment is it was a product of its time, you know, and the legal perspectives have significantly changed since that judgment in 1911. We are in a kind of a different world now, where the court cannot only look at the pecuniary losses, they must as well look at the non-pecuniary losses when they're approaching the claim for damages. So with this one, I think you will be able to answer that question one. It's a 20-mark question, so you must make sure that there is some kind of flash, but with this information that I've given you, you should be able to succeed in that particular question. Thank you.